Yes.
Your Lordship, yes. If I could now address you on what is effectively pages 8 to 13 of our skeleton submissions, which is the Mother's Appeal. Just before I move on from my submissions before the short adjournment, 2-page references from the hearing that was before Sir Jonathan Cohen on the 28th of April, where I said the learned judge set out very clearly to the father that he had a very limited jurisdiction concerning the children. They are 227 and 228 of the appeal bundle. Court of Appeal have said it's very perfectly proper exercise of my discretion, therefore discretion I have left in this country is very limited. And then further down he says the trouble is you're reciting argument that I have, please let me finish, you're reciting argument that I've already concluded. But then again he went ahead in May, 30th of May, and heard the application clearly and afresh and gave the father that opportunity. The order of the 13th of April is, of course, rather, if I can just turn it up, beg your pardon. Page 67 in the bundle.
Yes.
And the context of the cross appeal concerning paragraphs 2 and 4 of that order, which you can see at page 68 in the appeal bundle, is firstly, of course, the context of this court, or the court below, divesting itself of jurisdiction by virtue of the first order. That's at the top of page 66. Applications for the stay to set aside and for orders under the Children Act are dismissed. So domestic applications dismissed. So what jurisdiction then is the learned judge exercising when he orders at paragraph 2 and 4, orders concerning child 2? We've respectfully submitted that once the court below has recognised and enforced the order and it's been upheld by this court, our first position, as set out at page 8 in our skeleton submissions, is that the court doesn't have an Article 11 jurisdiction.
Can you help? Were these matters raised before the judge?
No. In that short hearing, no, they weren't. And I was going to take you to the transcripts where I don't raise these points.
So nobody submitted to him he did not have jurisdiction, or if he did have jurisdiction, it should not be exercised.
No, I did say, Your Lordship, I beg your pardon, I was going to point out, I didn't set it out chapter and verse, but if you look at...
What are we looking at?
The transcripts of the hearing.
Right, which is the one we've just got. Is that right?
Which is the one you've just got.
Yes.
You'll see there at page 13.
13.
13.
Yes.
Where I say a few lines down about...
Wait a minute.
5th.
This is the transcript of the 13th of May. Page 13.
Page 13. Electronic page 13. My Lord, indeed. About
my Lord,
a fifth of the way down.
No, if I'm looking at the right one, I don't see my Lord, indeed.
Do you have at the top of the page here on around 15th June?
No, page 13 at the top I have submission. This is an exchange between Sir Jonathan Cohen and Mr. Devereux. Is that the same as your 13?
Submission. Yes. Well, maybe...
Are the two page 13s?
Sorry, what are we looking for?
We're looking
at the top here on around by 15th of June. The passage that we're looking at is where I say, my Lord, indeed, I have to say this.
What does it start?
Well, my page, because it's smaller script, starts here on around 15th of June with with child 2.
Oh, I see, but that'll be a bit of different
Yes.
top, won't it? Oh dear. Anybody help?
Well, you started on our page 17. You appear to begin yours.
19, page 19. I'm sorry to interrupt.
No, not at all. 19.
Page 19G.
19, sorry, I didn't. E.
19G.
19G.
My lord, indeed. Thank you. I have to say this, your lordship, and you've heard this many times, so apologies for that, but you really are, with respect, limited, as you've recognised, in how far your jurisdiction goes in this matter, having made a decision that you've made in January. And the question is, and then his lordship rightly interrupts me and says, yes, it's a point well made.
And that's, yes, anything else?
And I have it as page 15, so a few pages on. It's a section where I say, in the same way that your lordship.
In a novel way of finding
Yes, I beg
messages.
your pardon. I start off by saying you could, of course, stipulate that passports are returned. For example, the solicitors returned the 15th June. And then his lordship says that, well, that is why I'm asking you to please be more specific,
Thank you.
or at least make it clear to my mind exactly what you're saying. And I respond by saying, in the same way that your lordship could, in the recital agreements of the last order.
Sorry,
The-
this is hopeless.
Beg your pardon.
Can we at least start at the same place? Page?
I think, were we on page 25, I think? Is
Yeah.
this apparent in the same way that your lordship,
Yes.
could in the recitals
25,
agreement?
I'm very-
Okay. Sorry, what's
Yes,
this?
thank you.
Yes. Same way, because what I'm referring to there is the order that I'll turn you to in a minute.
I don't think you
The
need
April
to.
the 28th order, which had a recital about mother's plans to return. Could, in the recital agreements of the last order, you allowed for the passports to
So
return?
during these exchanges, just to help, is the
Yes.
judge raising, are you making submissions on the judge making an order that submissions be given, and in the event of agreement not being reached, submissions being given, and the judge then deciding what order to make in respect of June, July, on the basis of those written submissions?
No. What we're saying is my client was agreeing, and we're saying it could be put in a recital.
Oh, okay. So when does the change of mind
Because
come?
its jurisdiction was limited, and so I can take instructions. And so then what happens is his lordship, of course, we deal with other issues, which were the outstanding costs proceedings in Russia. That was one of the issues that really concerned the learned judge, and the wording of his order of the 28th of April and what he'd asked for the mother to do, which he eventually, in his judgment, you'll have seen later on, accepts that that is good enough. What she did was good enough. There's, I beg your pardon, it's difficult with the page references, but 2 pages on in my version where I say, is that proportionate?
I haven't seen anything yet which says that the judge wouldn't have a submission to him, that he wouldn't have jurisdiction to make the order which he did make, and or if he did have jurisdiction, he shouldn't make it.
We made those submissions briefly by email later on, because it then became apparent, the learned judge, having asked my client, right at the end of that right at the end of the transcript, before you see separate transcript for judgment.
This is the top of page 31.
Thank
the
you
judge
very
says, is she, namely mother, prepared
Yeah.
to accept an order, albeit by consent, that she will return with child 2 no later than 15 June?
At that
Mr.
point-
Gupta, that's you.
Yes,
Yes, she will.
indeed. At which point my client nodded, because it was all done remotely, and I said on her behalf, yes, she will.
Yes. So you I mean, you'll forgive my coming at this from a position of
No, not at all.
relative newness to this field. it appears to me you're saying not only was she prepared to accept the order, but you, by implication, were accepting that an order could be made.
Well, there was originally an order, of course, in January which allowed for contact between father and children, or father and younger child, prior to departure. But what then took place, after my client had agreed to not go and agreed to come back for a period of 10 days, is the learned judge in his decision later on said, well, you can't actually have your passport when you thought you were going to get it, or child's passport when you thought you were going to get it on the 18th of May. I'm going to continue the stay to Wednesday. At which point, I sent through an email which is set out in the body of our skeleton submissions. You just bear with me one moment. Bottom of page 12, before the order was drawn and sealed, paragraph 14, skeleton submissions.
So where it's italicised, that's you.
That's
in
me
email,
making further written submissions about the court's lack of jurisdiction, especially now the order has been recognised. There also being no Article 11 jurisdiction on the 1996 Hague Convention is not urgent and no longer applicable in any event because of the court's substantive decisions. After the
But
court,
are you prepared to accept that on the face of it, in the course of the hearing, you didn't take that
Of
point?
course, of course.
Yeah.
I'm afraid, well, there it is. Learned judge is asking, it's all done remotely. He's asking on camera, we have this hurried hearing right at the end. My client, who's trying to say, well, I will come back, as per the order, if I turn you to 163, order of the 28th of April, what she said there in the recital, at paragraph 7, respondent informed the court she will bring child 2 back to England in June and July so they can spend time with the applicant. Court informed respondent expects to make proper arrangements, etc. It's consistent with that. She said it in April. In May, she's nodding to the judge saying, yes, I'll bring her back for a few days. But then the learned judge says, well, you can't actually have a passport when you thought you were going to get it. And she, through me, said, well, I'm not agreeing to this order anymore. At which point the learned judge made an order, not by consent.
I'm very sorry. I don't see the difference in principle between a consent order and an order the judge made in terms of jurisdiction.
Well, the learned judge made that order.
I'm sorry to interrupt. Parties consenting to something doesn't mean the court's got jurisdiction.
No, it doesn't. Indeed. We couldn't confer jurisdiction on it.
No.
What my client was doing was saying, yes, I'll agree to that. But then, when it came down to it, did the court actually have jurisdiction to make the order? The learned judge and court below said, well, if you're not agreeing to it, I'm nevertheless going to make this order without consent. And she does return on the 15th of June, despite my short email submissions. And the question for this court is, was he correct to do so? Did he have the jurisdiction to make those orders at paragraphs 2 and 4 about contact and about my client returning to this jurisdiction with the child she having gone to Russia? And of course the plan was, the learned judge's thinking was that she would come back for effectively 10 days, because what was being said during the hearing was that she would be here from the 15th to the 25th only, which is why if you go back to the order of May 13th, you will see that that's what's set out. At paragraph 4, order 4, shall remain in England until no earlier than the 25th of June. He was making, we respectfully submit on, not without jurisdiction, but making an order really that was only going to last for 10 days, because he was envisaging mother coming back, as she said she would, until the 25th of June, and then being able to go. If the court, however, is not with us with regard to there being no jurisdiction under Article 11, we respectfully submit that it was wrong to exercise that jurisdiction in this particular case, as we've set out at pages 9 onwards from our skeleton submissions. Of course, the question being urgency. Was there a need for urgency, an urgent decision like that? Where circumstances are that the mother has said in April, I'm coming back in June, has said it to the court in May, well, I'll be coming back with her. No need to make an order. Is there a need for an urgent decision where the court's exercising a very, as it said itself, a very limited jurisdiction? And we've set out the urgency type of cases, the submissions with regards to what Paul Lagarde on the explanatory report on the 1996 Hague Convention has said in the past. That's at the bottom of page 9 of our skeleton submissions.
Could you, we've got all this
Yes.
in writing, but what's the point of your appeal? What's it for?
Well, there was a moment in time, Your Lordship.
Because I understand you issued it on the 10th of June,
Yes.
before the latest round of events. But I mean, why are we thinking about this at all now?
Well, we didn't want to issue the appeal. Firstly, it was in the notice of objections. Secondly, we put in a respondent's notice, effectively saying we hope we don't need to launch an appeal on this. But the Civil Appeals Office said no, it's not. It's
But I mean,
premature to issue notice of appeal.
However you got there.
Respondent's
I mean,
notice.
for example, paragraph 2. Why are we being bothered with arguments about case management directions about parents putting forward lists of contact dates? I mean, and then come to what the only possible order is, an order that your client should return Sophia between certain dates, which have now passed.
Indeed.
Why are we wasting time on this? Why is money being spent on this? What's in it for anybody?
What we didn't want is for the court to say that we've accepted the court's jurisdiction on these points, whilst contesting the court's jurisdiction on other points. We contest the court below's jurisdiction, and as the court below made these orders, and we were dealing with this appeal in any event, firstly in the notice of objections, we tried to deal with it in a footnote, last footnote when you look at the notice of objections, effectively saying, let us not have to go there, please. And then
if you're right about the father's appeal, then it doesn't really matter. And if you're wrong about the father's appeal, the time has passed anyhow.
yes. Well, with great respect, there are so many instances when one gets to the appeal court where it's said to the legal team, well, you didn't question this at the time. You're not being consistent with your arguments, and you've let that one go, effectively. And so to counter that possible argument, of course, in this particular case, you can well imagine,
But in a sense, what you're doing is you're tabling these matters. But I can't really appreciate you're here and you're being asked about it. But in a sense, apart from tabling these matters, there they are. I mean,
events may have superseded the arguments, arguably. But if you look at, please, at page 37 of the appeal bundle, last footnote,
Sorry, 37.
37. This was 31st of May. Our initial, of course, response, notice of objections. I invite the court to read that. And what we don't want on our client's behalf is for anyone to say that she's in contempt of an order that she should have returned, and that there's some type of had consent application or anything like that, which is the kind of thing that has happened and been mentioned in the past. So it's not just for the sake of form. As you can see, we tried to avoid it there. Respondent's notice was put in, which is not in the bundle now, but also to cover that issue. And we didn't want to launch it.
Well, I think you're explaining. I think we have within the past day received a respondent's notice.
Yes. We sent that in for form's sake to ensure the court had that. But that hasn't been issued. Civil Appeals Office saying.
Well, you're not conceding the appeal. You're pursuing the appeal. So, I think we will have to address your Article 11 arguments.
Yes.
And if I can, it's easy to see it in the father submissions at page 21. These are extracts from Re J on the judgment of Baroness Hale.
Yes, yes.
When in paragraph 33 she said there's no precondition to jurisdiction that's impossible or impracticable. She sets out the questions: is the child here? Are measures necessary? Are they urgent? And then paragraph 34, obviously consistent with the overall purpose of the Convention, that measures of protection which the child needs now should not be delayed while the jurisdiction of the country of habitual residence is invoked. On the other hand, Article 11 jurisdiction should not be used so as to interfere in measures that are more properly dealt with in the home country.
Yes.
So your submission presumably is this is the latter, not the former. My question to you is, why is it not the former?
Well, we say it's not the former because contact was taking place. The mother, as I said, had indicated in April and again at the hearing in May that she was planning to go with child 2 and come back to allow for contact to take place. And there's a history of direct contact taking place on the ground in England. Orders.
It's quite difficult to make that submission when she went and hasn't come back.
Now it's difficult to make that submission.
So you're saying the judge should have accepted her bona fides when the proof might be that if he had, he would have been wrong to. So he might be argued that he was right as a matter of precaution to make an order for contact in the terms that he did.
If one's looking at it through the prism of what the court was looking at on the 13th of May, rather than what transpired
yes,
a few days later, then we'd respectfully submit that the court was wrong to make that order. She had a track record of direct contact. She had a track record of saying that she would be back.
So you're really saying there was no need for the order?
No urgency for that order.
The judge obviously thought there was.
Yes, he did think there was, and we respectfully submit he was wrong to think that. But the way that he reached that decision was originally by, as I said, right at the end of my submissions, asking my client, well, do you agree to an order that you'll come back? And her saying, yes, I've said that in the past. But I was saying, have had a recital, and the judge was saying, no, an order. It ended up being an order not by consent. But I take Lordship's point, Lord Justice Jackson, that it may be that the situation has moved on now, but we would ask the court respectfully to deal with that appeal, that cross appeal. And we are where we are with the mother now in Russia not wanting to return because of the fresh evidence, Ladd and Marshall application. And what that evidence is are two facts, really. And they're not.
Can you, before you embark
Yes,
on that, can you help certainly me? What does this evidence go to? What aspect of the appeal does it go to?
Well, we respectfully submit that if the learned judge, well, it's that last point, I suppose, subsequent events, what happened with the police turning up on the 20th of May, if the learned judge had known that the father was planning to report the mother to the police if she left, the learned judge would not have allowed her to return. He would have thought about it again. But of course that builds on my client removing in the first place on the 18th. I beg your pardon, yes, 18th.
And as you submitted, we have to decide whether the judge was right on the information he had.
On the information he had.
Yeah.
Yes.
So you say we shouldn't consider subsequent events. Slightly, yes.
It's difficult to run that argument because I've
But
put
it's
a point of
difficult,
time on the 13th.
difficult
of
to
May.
run two horses going in different directions at the same time.
Indeed. And having said that, the subsequent events that took place are issues that would have allowed the mother to make a set-aside application for his lordship on paragraphs 2 and 4, specifically on 4, to say, well, these are now the developments, and I believe a set-aside application was made to Mr. Justice Cohen, and he decided to leave it to your lordships because of those subsequent events. What has happened on the 10th of June is that he said words to the effect of, well, if she's going to come back here and be arrested, then I can't imagine I'd want her here.
So with all due respect, I don't see how you can leave it to us. Do you? I mean, there's not we are hearing appeals. We're not hearing other applications.
Well, again, to go through the process, we made the set-aside application to his lordship in the court below on grounds. Yes.
As I understood it, when you said leaving it to us, you were reporting what the judge said to you.
Yes.
Yeah. All right.
Excuse me. The other point on mounting our cross appeal is if you don't allow.
Sorry, I think it might be helpful for us
Yes.
to have that message. It's 382 in the call bundle.
Thank you. Yes, thank you so much.
So it wasn't. If that's summarised as leave it to us, it isn't transferred to the Court of Appeal. It's just I'm not going to do anything with this.
Yes, indeed.
While an appeal is outstanding.
That was a rather inelegant way of saying it.
Right. Okay.
Paragraph 4, I do not propose to deal with mother's application to me until the ruling is received. from the
Yes.
court.
There we go. Thank you.
Yes. If your lordships refuse the father his appeal, then that still leaves, of course, paragraphs 2 and 4 of the order, and that's the issue that we had. We didn't want there to be a lingering order. We thought that hopefully, as I said we said in the notice of objections, the court could just deal with it in the round, as it were. But to in the abundance of caution, we, having been told by the Civil Appeals Office that a respondent's notice was inappropriate, we launched that appeal. And while we're on that page 382, you'll see the kind of thing that the learned judges had to deal with in this matter at paragraph 7.
Yes.
So yes, looking at it as I'm inviting the court to do it, as to the information that was in front of the court on 13th of May, it's difficult for me to then say, well, there are these subsequent events, but we respectfully submit the court should have a weather eye on those developments to understand why it is the mother felt that she couldn't return right now, and secondly, the very fact that there are now contact proceedings in Russia. If the court has, it may be out with the actual appeal, but if the court has that information, we respect to submit that it is relevant going forward, knowing that this country that has already decided on the children's residence is now seized with contact application.
You say this evidence satisfies the Ladin-Marshall test, do you?
We said that it is important information that couldn't have been obtained at the time because it was subsequent, of course. And it may have affected the learned judge's thinking, but it hadn't happened at that moment in time.
Well, may have affected the judge's thinking isn't the test, is it? No. Would have had an important influence on the
Yes,
judge's
would have had an
decision.
important influence. We respectfully submit that it would have. If he'd known that there was potential arrest of the mother, then in our submission he wouldn't have ordered her return. In fact, he's said words to that effect on the 10th of June, and that's what started the application to get that information.
Thank you.
Sorry, just on Ladden Marshall. It's to do with the impact of the new evidence on the appeal. It's to do with the impact on the result of the case. We don't have to engage in a counterfactual of assuming that the judge knew something that hadn't yet happened. In order to be received, we would have to feel that it altered the case that was in front of us.
Yes, indeed.
Anything else?
Can I just double check? Thank you, Greg.
Thank you. Mr. Hames.
Thank you, my lord. You'll have our written skeleton on behalf of Child 1. You'll know that Child 1 supports mother's position really on both appeals and indeed the application for fresh evidence, so I can keep my submissions comparatively short. Child 1 is now over 16. She's anxiously awaiting her GCSE results. She is still keeping her options open as to where her future education lies. She certainly has not ruled out the prospect of returning to St Paul's after the long vacation to carry on her A-levels. But plainly that is contingent on not only the result of these appeals, but also her own examination results. She is particularly concerned at any impediment that may exist after this appeal, or depending on the result of the appeal, after the ultimate conclusion of any proceedings in this jurisdiction, to ensure that she, and indeed more importantly her sister and her mother, are able to travel to and from the United Kingdom without impediment or fear of any other restriction. And she is particularly concerned about the events in May where she was alone in her home when the police arrived. And you'll have seen in our written document how she reacted to that. My lord, plainly dealing with the father's appeal, the easiest submission for me to make is that if there is jurisdiction to set aside, that this court, as indeed effectively the judge below, adopted the same approach as this court recommended in B&B for the perhaps not analogous situation in setting aside summary return orders under the 1980 Hague Convention. And we respectfully submit that this was a classic example of a judge in full command of the detail of his case, making a decision at stage A. I'm looking at paragraph 89 of my Lord's judgment in B&B, and exercising robust case management powers. Plainly, I need to say no more if the court is with the mother and Child 1 on that issue. But we do respectfully submit that there is a difficulty with the question as to whether the High Court had jurisdiction to entertain and then make an order setting aside an order for the recognition, or indeed non-recognition, of an order under the 1996 Hague Convention. Plainly, we didn't have notice, on behalf of Child 1, of the hearing. We weren't there to make a jurisdictional point at the hearing below, so this is the first time on behalf of Child 1 that we've been able to make the submission in respect of the lack of jurisdiction of the High Court in setting aside orders under the 96 Convention. And my Lord, we note that particularly in the two authorities that we refer to, re W, decision of my Lord, re F, decision of Lady Justice Black as she then was, with whom the former President, Sir James Mumby, and indeed the current President, then Lord Justice Macfarlane, agreed. that they were reluctant, and I think I include my lord in this, to make a definitive ruling that there was a power vested in the High Court, very much preferring to leave it to the Rule Committee to make a decision as to whether there should be a rule or not. And we can't help but observe that the rules that were introduced by the Rules Committee into the family proceeding rules do not cover this type of order made under the 1996 jurisdiction. We accept that both my lord and indeed Lady Justice Black see good reasons why there might need to be an order or need to be a power in those circumstances, but for the reasons that we've set out in our written document, we would submit that different thinking, different reasons apply to this type of order. My lord, with respect, we agree that insofar as the effect of recognition of an overseas order is that the court in this jurisdiction would treat that order as if it were a domestic order. But it leaves the question of enforcement then as a separate issue, not the same issue as recognition, but as a different and subsequent issue to the court, which lacks the ordinary jurisdiction based on habitual residence, but nonetheless has decided that it will enforce the overseas order. It may be the case that sort of decision is more akin to a common law garden welfare decision that are made up and down the land by the family court. But of course, the decision to enforce and how to enforce is eminently susceptible to variation anyway, as to the most child-centric, the most appropriate way to enforce an order that has been recognised. But the recognition itself, we would suggest, is not so readily susceptible to a type of set-aside jurisdiction. It's not dealing with the particular factual circumstances or the arrangements of a child, still less with the type of forensic investigation or risk assessment commonly made in inherent jurisdiction proceedings, as well as into the 1980 Hague Convention. That's not to say that there isn't a remedy to a party, to a parent, who wants to question the arrangements that have been made for a child. And in this case, we would submit that if there is a change of circumstances, a material change of circumstances, as in other cases under the 96 Convention, the appropriate place to go is the court of the state with primary jurisdiction, namely Russia. My lord, then I leave that issue of jurisdiction, and I'm not going to repeat what's contained in the mother's documents. What we do draw attention to and have a particular interest on child one's behalf is the suggestion in the father's presentation that she is guilty of having some sort of secret or undisclosed intent. I think it's right to construe that as being almost an attempt to mislead the court as to her future education and her plans for her both secondary, for her next stage of her secondary education and her tertiary education. As of the 13th of May, apart from the evidence that her mother had not taken steps to remove the option from her of proceeding to day levels in St Paul's, that there was no evidence at all before the learned judge, as of the 13th of May, that she had specifically changed her mind and made a decision to come to this country in September. She is close to making a decision, subject to the matters that I've already raised. But it's if it's the submission of the father that this in some way affects the validity of the recognition order, we would submit that on any view it couldn't. It's clear from references in the judgment of the 12th of January that Sir Jonathan Cohen plainly had in mind, and my lord can turn to paragraph 7 very early on in the judgment, that in fact child 1 was simply keeping her education options open, except he was probably describing that in a slightly different context to explain why she was pursuing examinations both in Russia and in England. But paragraph 17 of the judgment, it's page 124, demonstrates in our submission that far from relying on a positive averral by child 1, in fact, the court was clear that she was keeping her options open. And my lord can also turn up, and I won't go to this in detail, paragraph 76 and 79, which are the section of Sir Jonathan Cohen's judgment dealing with habitual residence. 76 to 79.
Yes, yes.
And then there's a conclusion.
And at 77, 8 refers to your client wanting to return to Russia at the end of the academic year, envisages doing Russian equivalent of A-levels,
Yes.
and where she goes to university is not yet clear.
Yes.
So that's not quite paragraph 17, that's 77.8 seems to set
Well,
out what her position was.
17 deals with her keeping her options open.
No, but that's looking at history, isn't it?
Yes. But
Not
that
prospective.
has always been the historical position.
I'm not quite sure why we need to be hearing about all this, Mr. James. I thought, quite understandably, that your client didn't want to be the focus of attention. I'm not really quite clear why playing out this family situation from her point of view is really doing anybody any good.
Well, she does. She wants these proceedings to conclude as soon as possible. She wants the...
Well, we understand that. But
Yes. I'm just dealing with the particular points in the father's appeal which peculiarly concern her. And we heard this morning that if the father is successful, he wishes to examine the evidence of my client, which
we haven't
holds
from,
open.
we haven't from Mr. Tyler heard a headline point about any of this, have we?
Well, that was...
We made, because no stone is ever left unturned, buried away, there are things that people object to. I understand that. But this has not been something we've been having to hear from, even from the father's point of view, as a big point of our consideration. I just wonder whether this is serving your client's interests.
Well, it's submission that is made.
Yes, I understand that, but
That's all. And it is something that concerns my client, that she is going to be embroiled in yet more litigation about what she may or may not have thought, what she may or may not have intended when she signed those witness statements, which were before the learned judge for the November hearing. But my lord, if it's not going to assist, I'll say no more about that. My lord, the final point that I propose to deal with is just the question of anonymity. My lord, Justice Peter Jackson, raised the issue of whether, when Miss Justice Mostyn was considering whether or not to report, whether there was any attempt to make submissions against reporting. This is something that does exercise my client, child 1, a great deal. She suffered acute embarrassment by having her family name in the public domain. It was picked up by her school peers. She was not given any opportunity. This isn't a criticism of the learned judge, because child A wasn't a party to the Part 3 proceedings, but she was never given an opportunity to make a submission that he should not publish the full names of her family. She is acutely aware of that. We were only aware of that judgment when it was already reported in the legal media. By we, I mean her legal team. So it is something that very much concerns her. But I know that from previous your previous observations, my lord, that not only her name but her place of education and that of her family. It may be that the place in Russia should also, with respect, be anonymised if that's mentioned, otherwise mentioned in my lord's judgment.
Thank you. Yes, thank you very much.
My lord, I can assist further if it would assist. My lord has our written submission.
Yes, thank you very much. Yes, time. Oh, wait a minute. This is Everest.
Thank you very much.
Sorry. This is you responding to the mother's appeal.
I am indeed.
Yes.
Unless the court wishes me to embark on any other submissions relating to any of the points.
I think it was less rather than more.
Very generous.
Yes.
Very generous.
And I'm going to take that as a hint. I think it can be narrowly considered. I want to do so looking first at the transcript, second at the two relevant orders, those being the 12th of January and the 13th of May, and third, I want to be careful not to repeat matters, but just making some submissions drawing from the skeleton argument. So turning, if I may, to the transcript, two themes for the purposes of the submissions that I make on the transcript, we say are clear from...
Sorry, which transcript?
The transcript of the hearing before Sir Jonathan on the 13th of May.
Thank you. Yes.
The loose document.
Yes.
Two themes I pick out from that transcript, if I may. The first was a refrain, a continual refrain deployed by myself, that what the court needed to do was to provide the father with a proper opportunity to deploy his evidence and his submissions on the points that he wanted to. The second theme that I draw out of the transcript is that the mother repeatedly indicated that she was going to be returning child to this jurisdiction for the period of time in June when the parties were participating in their matrimonial finance dispute. And the points that I seek to make out those themes are as follows. If I could take your lordships just to a number of areas.
Yes.
First of all, page 1, C. At the outset, it was clear that the judge was anxious that this hearing took place over a relatively short span, and he was anxious that there was a limit really on the time afforded for submissions. And that's clear, for example, from his wish to move matters on right at the beginning. Well, we cannot spend too much time on this, when there was difficulty with some of the microphones.
I have to say, I read that as meaning we can't spend too much time making a fuss about the sound quality.
Yeah, I take that point, but when you add it in to some other observations, it's clear that the judge is keen to move through
I thought your point is made in the first line on the page, isn't it?
Yes. Page 2, A and B, an acknowledgement from myself that we're grateful for an allocation of the hour. It's precious time, and the judge had anticipated this application. Bottom section of page 2, within G, the second point that I make is I submit that the father should be given a proper opportunity to be able to have his issued new applications heard properly without them being rendered OTOs. I might have phrased that a little bit better in hindsight, but the theme is there. Then moving to page 12, please, at D, again, I repeat the point where the sentence starts ultimately. Ultimately, if the children, or at least child 2, because the applications concern her travel to Russia, and the court does not make a limited stay to allow the father a proper, albeit a properly proportionate ability to make his arguments, then it is, in my submission, unfairly prejudicing his rights, like rights of litigants to properly prosecute applications. Then at the bottom of the page, page 12, before you get to be able to say that, you have to give, in my submission, the father a proper, proportionate opportunity to deploy the arguments that he wishes to deploy, particularly in circumstances, I say, that there's no evidence of an immediate necessity for children to be returned to Russia. Moving on, page 16.
Can I just understand? These points are really points of reply, are they? Or points in support?
They
of
are, but as I was in the transcript...
I think we need to keep an eye on what's happening here. I mean, these are really points in amplification of what
Yes.
Mr. Tyler told us already.
Yes.
I thought you were replying in relation to the mother's appeal, which your second point definitely goes to.
You're absolutely right, but I felt that if I was in the transcript, I might as well...
The thing is, we are aware of this because they were referred to in the submissions.
Yes.
That the written and oral, the primary submission was proper opportunity to be able to deal with the applications, file more evidence, more submissions, and have a longer hearing in due course.
Well, let me accept Lord Justice Peter Jackson's invitation to move on to the main event, so
Good.
to speak. Page 18, if I may.
Yes.
I rely on the passage from E to G, where Mr. Gupta unequivocally indicates that the mother would be returning with child 2 by the 15th. And then over the page, page 19, again at the top, A, he's agreeing that she would be returning. But E, yes, indeed, Mr. Gupta says.
Sorry, E.
E.
Yes,
19E. Yes, indeed. With these arrangements, of course, when child 2 comes back on or by the 15th of June, then we'll carry on.
Yes.
And then, of course, then we go to paragraph, page 22 at D, again relating to her returning child 2. And then finally, as we saw at
Yes.
page 31, when the judge asked Mr. Gupta, she prepared to accept an order, albeit by consent, that she will return with child 2 by no later than 15th of June. Yes, she will. We've seen that already. So, again, the point's been made that nowhere was the jurisdiction at that point challenged. In fact, it was actively accepted. If one goes to the order of the 12th of January, which is page 147 of the bundle, that made a number of orders for contact, paragraph 23, relating to child 2. That's page 151 or 159.
Yeah.
But the recital at 148 or 156 indicated the acceptance by those at court, including all members who surround me on the front row, that...
Sorry, which recital?
Recital 13.
13, thank you.
Page 148. provides the interim child arrangements for the children are made pursuant to Article 11 of the 1996 Hague Convention and or Article 20. So at least in January, all of those who were here before you accepted that there was a jurisdiction available and that there was a jurisdiction that was available to make orders for contact. If one turns then to the order being appealed, which, as we know, is page 67, I want to agree with agree with part of the view of Lord Justice Peter Jackson. Paragraph 2 is essentially a case management order, which simply provides that both parties are to set out their suggestions or their proposals for contact arrangements in June and July, during the period when the parties are litigating in this country. But it's important to emphasise that it was proposals within this country, and I adopt Lord Justice Peter Jackson's view that the letter that then gets sent after birds have flown, so to speak, is really window dressing, because all it does is it doesn't provide for any time spent with the father and child two in this jurisdiction, but says come to Russia. The paragraph 4 is obviously an order of substance, and we deal with that in our written submissions at paragraph 56 onwards. This goes an argument, and I'm acutely conscious that you've read that, and I'm not going to win any plaudits by repeating what's within that document, but we seek to suggest, and it appears to have at least been accepted by all of the parties here previously, that there is jurisdiction based on Article 11, and indeed potentially on Article 12, although our primary case is Article 11. The objection to Article 12 is obviously that it doesn't have extraterritorial effect, but in circumstances where, for example, there are assets in this jurisdiction, or it's likely then that the party is going to travel to this country, in my submission, the extraterritorial effect doesn't prohibit the exercise of that jurisdiction under Article 12. An order can be made, it just can't be enforced in Russia, but it could be leverage relating to it could be brought to bear on a party who's in this jurisdiction. But I acknowledge that there is obviously a distinction between Article 11
Yes.
and Article 12.
Yes. And you draw our attention to what was said in the order of
Yes.
January. Yes.
And I rely on what we say in that passage from paragraph 56. As I say, I'm not going to repeat it because it's
Thank you.
the quarters have it well in mind. Lord Justice Peter Jackson makes the fair point. Well, what are we actually doing here? Firstly, well, in terms of this part of the appeal, the first thing he says is, well, it's a case management order, and it's a case management order, and really, in my submission, there can't really be much of a challenge to that. The second is, well, the time has passed, and however we got here, we've now passed the period that was in issue. It's of some importance because the parties are likely to be in this country litigating, knowing the enthusiasm with which they do litigate for some period of time. It may be that the court would wish to order another period of time when child 2 is brought to this country for periods of time to spend with the father. And so the question of jurisdiction does actually have
Yes, I'm not sure if we were to or do, upholding the order, the provisions of the order that the judge made on the 13th of May, would have any consequential impact on any future.
Would if you said if you said there was no jurisdiction?
But it would if not. But if we, as I said, if we uphold the order, I don't think it would have any significance.
Well, I take
because,
that point.
because
But
the
if you were,
situation is different.
well, it's obviously going to be considered afresh and the particular circumstances.
I think that's rather a dangerous.
But if you were
height
to,
to
if
fly.
you were, well, I'll haul it in if it's not flying well. But
I did say fly. I should have said seek to fly. Yes.
it's one of those occasions when one throws it up, hoping the wind is going to take it, and it actually
No,
hits
I
the
actually
ground.
think it. I do think it's rather a dangerous submission.
But I think the
because-
submission can be well deployed in relation if you were to say, well, there isn't jurisdiction.
Yeah. Well, that's yeah.
Um,
Right. Yes.
I think that's the extent of any
Thank you.
attempts to fly kites around
Yes.
matters that I want to deal with.
Nothing? No. No. Thank you.
Now, do I need to reply to the response to the appeal? If I do, then I can do so now very, very
Do
quickly.
say very quickly, please.
Point of information, the hearing lasted 2 hours and 42 minutes.
2 hours and 42
42
minutes.
Well, by that, one can read into the fact that the learned judge heard it for almost 3 times the allotted amount of time, and we respectfully submit thought things through carefully. That's on the main appeal, but of course, in response to one of the friends, the respondent to our appeal, we respectfully submit that events have led to. Well, you've just heard those submissions. You've heard the dangerous submission. You can see that the reason why that appeal technically had to be made, because we didn't want there to be an order which then it links into future applications, effectively.
Thank you.
Thank
Yes.
you very much.
You were after a few minutes. I don't know. I think perhaps do we leave open whether you're going to, because the way Mr. Devereux started his submissions, it appeared that he was taking the opportunity to reply to Mr. Gupta and Mr. Hames's submissions. But is that what you're now going to do?
I'll get in 2 quick points, I hope.
Right.
First is this, please. In reply to Mr. Hames' suggestion that the appropriate procedure in relation to setting aside a recognition order, if there's been a change of circumstances, is to raise that in the country of the recognised order. By definition, in a case such as this, when we are seeking to establish a change of circumstances of sufficient moment
I
to...
think what he was saying is if the argument, okay, if you thought that's what he was saying, I thought he was saying that, okay, go on.
I thought he was saying,
No, I think he might.
if things change,
think
don't
he
go
might
back
be
to
right.
Sir Jonathan Cohen and ask him
Yes.
to set aside his
Yes.
return order. Go to Russia and
Yes.
say, can you vary the order, please?
Yes, yes.
When, by definition, we're seeking to raise an argument that it defends against English public policy to recognise a Russian order, especially when we're saying in terms it is because of Russia's foreign policy, court system, etc., it defends against public policy, it's an extraordinary notion that we should go to raise that argument
Yes.
to Russia. There may well be circumstances when...
Yeah, because your argument, anyway, as I think we established this morning, is that the judge should have gone further down the road to reconsidering his decision to recognise the order on the basis that it didn't offend against English public
Yes.
policy.
And the different things, should that order be set aside, is different from should a Russian court exercising Russian law change.
What I was saying is I thought for a moment that Mr. Hames' submission was directed towards enforcement, and I can see an argument that if you're dealing with can the order be enforced, can it not be enforced, how should it be enforced, that there's an argument for saying issues of that sort, if this country thinks it's not in a position to deal with it or embark on any effective enforcement, should go back. But that's a very different
Yes.
point.
Right.
Yes.
And wholly separate points then, Mr. Gupta relied on the transcript of the 28th of April hearing and what was said then by and on behalf of the father,
Yes.
and the fact that arguments were effectively mirrored in the set-aside application. And my response to that also goes in some way to dealing with Lord Justice Peter Jackson's remarks in relation to the lack of promptness in bringing the set-aside application. The specific circumstances are important. This was a period when the father was being kept out of funds to pursue the children cases, if I can put it that way, running up debt with his then current solicitor, acting in April in person with the assistance of a non-qualified friend, and being told in terms by the judge, rightly for that hearing, you can't raise these arguments, I've dealt with this. Paying in part himself from the maintenance paid by the mother, and in part on credit effectively with solicitors, the father found a way to be able to make his new arguments in a way which meant the court could consider the new facts and whether they added weight to previously run arguments. And that was the set-aside application with the other two corollary applications that were made and which have been the subject of this. So he would say that the context is all important, both of the April hearing and of the absence of funds in that period in circumstances when the mother was drawing very heavily on funds to pursue her arguments relating to the children. Lord, I think that applies to the appeal. Is there anything else then in relation to the appeals with which I can assist?
No, thank you. Right, we're going to rise for a few minutes.
He's a fantastic comedian. Great comedy.
So, what's happening now?
6 foot 7.
Or just a decision about that decision. When's it going to happen? Yeah.
Because we allowed January after this.
Yeah.
So there was jurisdiction.
But
I can't guarantee. If she comes in.
Be an interesting split. Are we still live streaming?
Yeah, such kind and fair judges. But,
well, what's happening on the computer? No, he said he was sending me messages as well.
yeah, so.
It's our case, just very, very simple. That's right.
Yeah. Someone has some nibbles because
Yeah, definitely. No,
what's that lazy ballerina place? It's on High Overs next to Apex Hotel.
Okay.
Some cocktail.
Yeah, sounds good.
You look it up.
Perfect. Lazy ballerina. Right. Did you get your note done, Helen, last night? All night?
So which month?
Well, you need a drink then. Lazy ballerina.
Have you been there? I've always walked past it. I thought it's a bit of a weird.
Okay.
What is the date today? 26th?
26. Yeah, you do, don't you?
Yeah.
Yes, I know. And I actually mustn't have in my back as soon as I can see the rip in my trousers. Helen. Massive rip in my trousers. He's just walking out of the office and Hannah went, "Your trousers are all I have no idea. Actually, I haven't worn this suit for probably last time I wore it.
All right.
Thank you very much. We have reached a clear view in respect of both the father's appeal and the mother's appeal from the provisions in the order of May. And that is that both appeals will be dismissed for all reasons to be given in our judgment or judgments to be handed down in due course. One of the objectives of telling you our decision in respect of those appeals now is to assist to focus attention on what issues remain to be determined in respect of the application for permission to appeal. Now, are there any outstanding issues in respect of the dismissal of the appeals which we need to deal with now, or can they, as would be conventional, be dealt with once the draft judgment or judgments have been distributed? As you know, they're distributed for your purposes only, for typographical corrections, not to be used for any other purposes, not to be distributed more widely. And I say that because, as you know, it would be a contempt of court if they were misused. And as I say, it would be conventional that any outstanding issues are dealt with on short written submissions. But I just raise, is there anything that you think would be better ventilated now? No?
Well, I can't immediately
No.
think of anything.
No. Thank you. And Mr. Hames, I think you can now
Thank
leave.
you. If we may be excused.
Yes.
Thank you.
Yes. Yes.
Well, there remains the outstanding application for permission to appeal in relation to Sir Jonathan's refusal to make a funding order.
Yes.
I've not had a chance clearly to see whether that application is affected by the decision handed down. But
Well, first of all, can you help us as to the scope of the application as it was made below and how it was dealt with below?
yes,
Because speaking for myself, I found that rather difficult to, put it colloquially, work out.
well, I'd hoped that when we received the transcript, we might be a little bit clearer about that.
Are we?
Well, I remain as clear as I was when we wrote in our document that we suspected the transcript would allow us to say that the matter was fairly cursorily dealt with.
Would you mind, now that we've moved away from what we were talking about earlier on, could you just trace the progress of the application from the point that it was first made through to the order?
Does Moylan mean the application for the funding?
Yes, for that funding order, yes. Just so we have afresh the sequence of events.
Forgive me while I just find the applications. Well, the application for the funding order was made on the 26th of May.
Are you tracking or Mr. Tyzak's skeleton argument?
I'm looking at the moment at the order refusing that part of the application at page 72 of the appeal bundle.
I see. I mean, it's not technically, is it, as legal services payment order? Is that right?
I think it's a legal costs funding order.
Yeah.
Legal cost payment order.
But is that, displaying my ignorance, is that under the statutory provision? Because the cost funding in the Matrimonial Causes Act only applies to financial proceedings, doesn't it? Financial remedy proceedings. But the court has developed a jurisdiction to make costs orders
Yes.
in respect of other proceedings, including in particular Children Act proceedings.
Yes.
Okay.
Which is why in my document I refer to it as an LCFO rather than an LSPO.
Yes.
Because it
Because
is
an LSPO is a term of art. Isn't
Yes,
that what their
it is,
court
that's
described in 22Z or whatever it is of the Matrimonial Causes Act? Okay. So that's why I was wondering, because you see there were a number of applications made as determined by the judge at this hearing, including one in respect to Part 3, and this order is Part 3.
Yes.
I.e. the heading is Part 3.
Yes. But the order would be made in the Part 3 proceedings, as I understand it, even if it were to be funding any other proceedings, including the children proceedings. So that was the correct forum,
Really?
that's the right word, in which the application's been made.
Well, okay. Anyway. But so you're saying the application of the 26th of May was for all aspects of funding?
Yes.
Okay.
And as then developed in the argument in the transcript, one sees the different strands of that.
Yes.
And we'll have seen that our particular complaint forming the basis of this application relates to funding for children proceedings, and we
Yes.
split that into historic but
Yes.
with then current solicitors' fees and prospective fees. And if
I'm sorry, I was just catching up the various documents. Where did you say the application itself was?
I don't think I've seen that.
Well, I hadn't yet found it yet.
No. Well, forgive. I'm sorry that's not there. If it's no, we will
All right.
get it out.
But I'm just wanting to find out where was the best place to find, as it were, the request. Is it Mr. Carruthers' statement, which 212.
You see, what we're grasping for is an identification of what matters were put before the court
Yes.
on which the judge made his adjudication determination.
Yes.
Because until we know what he was asked to do and why he was asked to do it, it's rather difficult to go on to consider the questioning of his decision.
Well, yes, well, Mr. Carruthers' statement
7th of June. So the order was the 10th of June.
Yes, and the statement's the 7th of June.
But is that what contained the material that the judge was acting on in this regard?
Well, that plus then the submissions made that we see transcribed in the recently.
But one would expect, because I haven't read this statement, one would expect to pick up in this the claim in relation to the Children Act proceedings. I mean, I'm looking, for example, at paragraph 27. Which looks as if it might be in the general
Well, that's a debt in the Children Act proceedings. As
Well, it's not a debt, just a debt, but it's also ongoing work.
Yes, so one half is the fees, the first sum, and then 4 or 5 lines down, an estimate of further fees, specifically dealing with the ongoing issues relating to Child 2's removal.
But is that where essentially the evidence before the judge in relation to this issue springs from?
Well, yes.
I mean, if there's anywhere else, do say, but that seems to be relevant,
Yes.
at least.
And if one looks at the transcript, which is, I think, in the second supplemental bundle.
Hold on. Yes.
One sees.
So can I just? So what was being sought is an amount just under 50,000 in respect of incurred costs.
Yes.
An estimated amount in respect of what's described as ongoing and potential issues relating to the younger child's removal from the jurisdiction, and then this very large figure for future potential applications.
Yes.
So there were 3 aspects to it.
Yes.
Right. Yes.
At page 32 of the transcript.
Can I just on this statement, the last line in paragraph 27 says the legal funding sought by this application in relation to the children proceedings is, and then there's the very large sum of money. So is that what was being applied for?
Give me my lord, which paragraph?
27, page 218. At the bottom, well, you're looking at it electronically. The last sentence in the paragraph, which finishes with the very large sum of money involved, and it reads, the legal funding sought by this application in relation to the costs in the children proceedings is. So, am I to take it that that's what the application was for?
No, just check that, please.
Yeah.
Yes, but that's included then the costs of a future set-aside application in the event of the appeal, this appeal, the last appeal, having been successful.
Right.
And in fact, the claim, so far as it's complained of in the submissions, was for the 50-ish outstanding and a sum of 50-ish for future.
When you say in the submissions, you mean in the submissions for the hearing in June?
I mean, the oral submissions per the transcript.
Right, okay. So you're taking us to the transcript.
Just to be complete about this, there was, but I'm not sure we have it, a schedule lying behind those figures. But
Yes, I've just seen that isn't and
It
should
isn't
be
there,
appended
okay.
to that. So
Okay.
sorry for that.
I thought I'd seen something.
Oh, is there?
Well, I don't know whether it's the same. If you look at page 231, it's too small for me to read. But is that? I couldn't work out whether that was it or whether that was something else. Because I can't read the figures. Then a magnifying glass. Is that everything, or is that something else?
Well, there's an even larger figure at the end of sort of the final
Well,
figure
that's
on
the
page
part.
232.
I think that's the part 3.
That's
That's
just
the
part
part
3.
three.
Okay,
Yeah,
thank you.
okay.
Sorry. Yep. So the transcript.
At page 32.
Yes.
Picks up after a short break with Mr. Tyzack addressing Sir Jonathan. So that's the beginning then of the LASPO application as it's put there. One sees at F, Mr. Tyzack asking for funds in relation to outstanding costs in relation to children. And being told by Sir Jonathan, at the moment, I struggle to see how anything in relation to the children gets off the ground until the Court of Appeal grants permission. Isaac acknowledges he understands that point, but makes the point there that at that stage, child due was due to leave the country, come back to the country, and dealt with the fact that at that stage it was known that the wife was appealing the order. And seeking representation for the husband in that. That's an issue, says Jonathan over the page, which might arise until granted it's premature. Mr. Tyzack commented on there being a period of time when child 2 was due to come back, and steps may be necessary. Of course, we now know that the order seeing her coming back hasn't been complied with. Jonathan says, I have no jurisdiction, or arguably I have no jurisdiction in relation to it. Which is a curious comment, we would say, in light of the fact that his lordship clearly thought he had jurisdiction to make the order. The point was made at C that significant funds were being defrayed by the wife, qua mother, the legal fees. And then as E, one sees Mr. Tyzack referring to the amount outstanding with the father's solicitors. And the point we make is these were his then solicitors, and also have seen that in the statement from Mr. Carruthers, which we looked at a moment ago, Mr. Carruthers said this firm cannot work on credit on the children's matter further. The response to the father owing that money from Sir Jonathan E is he took this, I think that was in Mr. Carruthers, he took that view with his eyes wide open.
Sorry, where are you?
I'm at E on page 33.
Oh, yes. Yeah.
When Mr. Tyzack asks towards the bottom of the page for money in order to make reasonable applications to see child 2, shouldn't be precluded from representation, he's told that this is cloud cuckoo land. What he's suggesting he's going to do, correspondence, let's get on with the main thrust of this, Sir Jonathan says. In the middle of the page, D, Mr. Tyzack makes point, I'm not asking for significant sums in relation to this, but something to enable him to have representation. What are you asking for? £47,000 that's outstanding, and a further additional sum to cover such works may be required over the course of June to make sure that period over the 10 days does in fact take place.
Sorry, so just while we're following this thread, could you situate us back in a period in June when Mr. Carruthers was writing his statement and the judge was considering it, and Mr. Tyzack's arguments? At that stage, it was known that child 2 was in Russia. It was not known that she would not be coming over in a few days' time.
It wasn't known, no.
It wasn't known at that stage that she was not coming over in a few days' time.
The father had issued an application to appeal. I think the mother had either issued or indicated an intention to issue her application for permission.
The appeals we've heard?
Yes.
Yes. So, what activity was the father seeking funding for as at the 10th of June? What was it that he needed legal funding for
To enable,
at that point?
to enable his solicitors to do whatever would have been necessary in order, for example, to ensure child two's return to the country.
But at that point, in any reasonable world, nothing was necessary.
Well, this isn't a reasonable world. There have never not been...
Exactly, but that it wasn't a usual legal funding application where one has, for example, an upcoming hearing, and you're saying this is going to cost X, I need Y in order to be able to be fairly represented at it. In this case, the judge was facing an application firstly in relation to past funds.
Yes.
But that doesn't, is that featuring yet in this dialogue with the judge?
Yes, that's the part where the judge said he went into this with his eyes open. And there's further reference.
Right, that's the past, that's Mr. Carruthers' 50,000.
Yes.
So the forward-looking one is £47,000, but £47,000 for what?
No, the 47,000 is the incurred costs.
50,000 plus, sorry, is the expression. So 50,000 plus for what?
So at that stage, it was being asked for to progress his appeal, to respond to the wife's appeal. It was also in order to address what was then known about the wife's having, we use the term sidestepped, the Court of Appeal order.
But when you say progress his appeal was issued on what date? The appellant's notice was dated the 17th of May on your side.
Yes.
And on the 10th of June on the mother's side.
Yes.
So what is Mr. Carruthers' statement saying we need money in order to appeal your order?
Mr. Tyzack was saying that in the submissions.
Right. This is what I wanted to grasp from what's being said.
Well, we got to page 34 yet. Bottom of page 34. Mr. Tyzack, first section, £47,000 outstanding. Second section, Court of Appeal proceedings, not an issue for today. Third issue, ongoing potential issues.
Yes.
So, Court of Appeal costs, not a matter for Sir Jonathan.
No, but I think in circumstances where 2 pages earlier, Mr. Tyzack had been told there's nothing happening in relation to that unless and until permissions are granted.
Right.
So as at the point that my Lord's pointing to there on page 34, yes, it's some outstanding and a sum for future issues. And there were, of course, the 2 periods of contact which Sir Jonathan had expressly indicated in the recital ought to be taking place. One, the specific dates in June, 2, over the summer more generally. In circumstances when it was then known that the order of Lord Moylan had been treated in the way it had been, and in the knowledge that it would certainly be necessary for at least some activity to take place via solicitors in order to enable the father, at the very least, to take advice on how to enforce what he would say were his rights, the stay having been treated in the way it has been treated. And
that's how it's explained at the bottom of page 35, Mr. Tyzack again.
Yes.
A modest sum to enable representation over to 4th of June. I don't quite understand the reference to 4th of June. Given this was happening on the 10th of June, perhaps it's a transcript error. It's a reference to the trip back in June.
Yes.
And apparently a reasonable figure for that was going to be £50,000.
Well, we make the point that these are very small figures compared with what we think the wife was spending during this period. There's been limited transparency in relation to that, but vast amounts
Anyway, but that's what Sir Jonathan was being asked
That's
to
what
do.
we're being asked to do. And
47,000 plus 50,000.
And his lordship was, I don't mean this in any way rudely, giving a sort of running commentary of his thoughts in relation to submissions being made. The argument moves on, and then the judgment is at page 44.
Before we get to the judgment, this exchange continues, at least on Mr. Tylak's behalf, up to page 39 at the top. As you say, with a lot of interchange. Is this the passage that relates to this issue?
Well, no, I think that passage moves on beyond the application for those two specific sums in the children proceedings,
Right.
to do with other aspects of the legal cost
Yes, I see.
application.
Do we end on page 35, effectively?
Yes.
Because and so,
So the judgment at page 44.
yeah, just before we get there, the three elements that had been identified, one was to do with costs, debt,
Yes.
47,000. One was to do with the costs of bringing the appeal,
Yes.
unitemized or itemized.
Well, I don't know, but that was parked in any event as we've seen.
But and one was to do with was effectively a fighting fund
Yes.
to keep in a case where litigation is going on all the time. It was to keep the tank topped up.
Well, slightly more than that. Not litigation all the time. The child removed from the jurisdiction in the way that's been seen, in circumstances where the judge, Sir Jonathan, had already set out the periods during which he said there should be meaningful contact between the father and the child. So, not just a very real prospect, a near certainty. Certainly of the need for lawyers.
But
And-
for purposes as yet unknown but confidently
Well,
predicted.
Well, in order
Well, to engage in correspondence
Yes.
about the
Correspondence.
child's removal,
Yes.
to engage in correspondence about the contact.
at the least.
So in response to the letters that we were
Yes.
shown by...
Yes.
Uh,
And when,
yes.
forgive me,
no, go on.
when, for example, one sees the order of Mrs. Moore and then sees that the documents directed weren't complied with, when, if we're right in this assertion, the removal was clearly in the knowledge that it was against what was intended by a Court of Appeal judge, in circumstances where at the very least correspondence was necessary. Also advice was necessary in relation to what steps, if any, could be taken in the extraordinary circumstances with the recognition order as it was, the set-aside application, the appeals, etc. So, on any view, a labyrinthine legal situation and a child not where it had been anticipated she would be, and no real knowledge of what the proposals were in relation to that child and her seeing her father.
Yes.
And of course, as we've heard from Mr. Gupta, even though this court hadn't determined our application for permission, the mother was acting on our appeal as well as in her prospective appeal at that stage with respondents' notices, etc. So it wasn't a complete lull between our application for permission and this court's grant of that permission.
Yes.
And my lord knows that the mother issued an application to set aside the order of Sir Jonathan as you heard confirmed a moment ago. The judgment is at page 44. It may be that it doesn't need more than cursory consideration, because page 53.
Sorry, 53.
53. So after the judgment is dealt with and after various other exchanges have taken place, after discussion then about experts in relation to valuing Russian business interests, between B and C, Mr. Tyzak reminds the learned judge, yes, and there was obviously this submission I made earlier in relation to...
Sorry, 53 of the transcript or 53 of the bundle?
Between of the transcript.
Yes.
Mr. Tyzak, between B and C, and there was obviously the submission that I made earlier in relation to some costs funding in relation to children issues. Sir Jonathan Cohen, well, I'm not impressed with, for the reasons...
Sorry, I still haven't... Oh, wait a minute. Got it, found it. Yes.
So it looks as though his lordship had already expressed in the to and fro of submissions his views about that, which were effectively Mr. Carruthers took that work on at his own risk, and that there was nothing for which his lordship thought funding should be made available in relation to the children case.
So it's he took that view with his eyes wide open, is that?
Yes.
Right.
It's also page 44, isn't it? Paragraph at the end of the page is of general application, isn't it?
Yes, Mr. Tyzak asked to finish his submissions, referenced again the outstanding costs.
Also page 45. From E onwards, where although the judge is dealing with...
Sorry, 45.
45.
Which page?
I'm sorry, I'm reading from the numbers in the bundle, which are not the transcript numbers, but the
Yes, the
bundle numbers.
43 where?
44.
44.
44 at letter F. Last paragraph. (45) letter F. Appreciate that 45 and 46 are to do particularly with the third part 3 proceedings.
And I think one of the submissions you make is the judge, the provisions of the effect of the provisions in a number of orders is that the mother has unlimited access to this fund, even though it might be thought she had access to other funds outside England and Wales, but she has unlimited access to those funds for the purposes of instructing solicitors in respect of the children, putting
Yes.
it broadly.
So the effect of Mr. Mostyn's order, so this came before Sir Jonathan Cohen's decision, was that the mother could use the Coutts accounts as she saw fit in relation to any incurred costs, but not to pay on account, subject only to her solicitor certifying the costs had been incurred, and without any check on the spending, whereas because it was her money, even though it had been frozen
Yes.
because of the Part 3 application, whereas the father would get only what he was specifically and explicitly given out of it. At various times, that has led to difficulties in that the father's given a sum which matches the mother's budget. If the mother overspends on her budget and the father learns about it after the event, it's difficult for the proverbial playing field to be levelled.
But the discussion and request for an order was being considered on the back of the mother's offer of a pound-for-pound system, which had been endorsed by Mr. Justice Mostyn. I mean, it's said on the mother's behalf that since August 21 or something of that sort, she had agreed to a pound for pound
Well, the
system.
prevailing pound for pound situation is that costs budgets are agreed for the next part of the Part 3 proceedings, and if the mother overspends on hers, then she has to make good to the father retrospectively. But in relation to the children cost being asked for here, as you see, there's no reference to what the mother spent. We think she spent far more than the father was talking about. It was simply a refusal to pay the debt to Mr. Carruthers on the basis that my lords had seen, and a refusal by his lordship to make any further money available for the so-called
Was
fighting.
there a pound for pound regime on offer or endorsed by the court in relation to any children proceedings? Right, so you say the pound for pound, I'm not doubting it, I'm just trying to catch up with this. You say the pound for pound was only in relation to the Part 3 proceedings?
Well, yes, let me...
And only in respect of excess.
Well, yes, it's at page 73 of the bundle.
Sorry, page.
73.
Of which bundle?
So the specific application for commission bundle.
Paragraph?
Paragraph 23. So paragraph A of 23 allows the principal sum to cover the legal costs, subject to pound for pound increase. And of course, the difference between the numbers represents the fact that the mother doesn't pay VAT, but the father does. They're otherwise equivalent.
But where does it say that this is... it's the legal cost of the Part 3 proceedings,
Yes.
and there's no equivalent in relation to
No.
children
No,
proceedings.
that's our complaint. These are the criminal proceedings that should have finished on Friday just gone. And then there's provision for cost for a shadow expert. And then 24, of course, relates to release of funds to pay the historic debts in relation to Child 2.
Yes.
And that's effectively it. So our complaint, which we set out, I think, fully in our skeleton argument on this issue, is firstly, it was wrong in principle not to allow for the payment of the historic costs. There's a distinction in the case law, in the case of Rubin or Rezed, both of which I set out in that document, between historic costs to then previous solicitors, which are simply debts which can be chased, enforced in the usual way, but don't impact in the normal course of events on access to legal representation, as opposed to ongoing debts with current solicitors, which may well impact on access to representation. And of course, we had in this case, Mr. Carruthers, the assertion in his statement that he was unable to continue to provide credit as it was in relation to the children application or children issues. So on the one hand, Child 2 is being allowed access to the funds in order to pay off a debt. And we recognise that permission hasn't been granted in relation to our complaint as to that, but it's relevant, we say, to the reasonableness or otherwise of the refusal to provide funds to the father to pay off an active and relevant, at that stage, ongoing debt.
Where did the funds come from to pay for the application of the 12th of May?
The father's been provided with maintenance, living expenses. I say been provided, for example, in February, March, April, it wasn't provided until after the event when such as Mostyn enforced that. So the father, and I know the court will look at the legal fees and form one view about the parties, but the father has no other source of income but that the mother pays his rent and the mother pays for him to live. And it's from that, and I think borrowing money, that the father's had to pursue, had to use in order to pursue legal remedies when he hasn't access to money, or end up with a debt, for example, the debt to Mr. Carruthers. I've been in circumstances in which a solicitor comes to court, and I've set out, so I won't repeat it, but for example, Mr. Justice Cobb's remarks in the Z case, there's a real distinction between a previous solicitor and a current solicitor. At page 9 of my skeleton, I'm of the view it's neither fair nor reasonable to expect the firm and chosen counsel to offer unsecured interest-free credit in order to undertake their work. In this respect, I'm concerned that the mother and hunters should not become bound or beholden to each other by the existing debt. And whilst I don't seek to go behind the veil of confidentiality between a party and solicitor, one of the issues of contention is always if there is a need for credit to be run up because funds aren't ultimately available.
Does the transcript show what the £47,000 consisted of? I mean, it presumably was in the annex to the
yes.
statement. Do we not need to see that annex at some point?
Well, yes, I'm certainly happy to make sure that's available.
Yes, we have the bill, but we don't have the, or we have a bill or two bills, but we don't have the.
Yes.
I don't think all of it.
Can I ask Mr. Tyler, at page 54 of the transcript, well, page 51 of the internal numbering, 54 of the bundle, where Mr. Tyzak says there are those outstanding costs of £47,000. That's what we've just been talking about, is it?
Yes.
Yes. And then the judge says, I'm not giving judgment today. You can deal with this and you can come back and make another separate application. And he went on to say, I'm not going to say anything more on it today, and I'm not intending to give a judgment today. And I mean, I've done my best to try and see if there's any further reference to it, but that appears to be it.
Yes.
So in fact, you didn't get a decision at all.
Well, I think the closest we get is page 53. Certainly for the historic fees. Let's see, which I'm not impressed with for the reasons that I've given.
Yes. But and then the next page he says, when he says I'm not giving judgment today, you might think, well, that means he's not going to give reasons. But he goes on to say you can come back and make another separate application.
Yes, without funding to do so.
Right.
Well, it was clearly a difficult hearing and an awful lot was dealt with. And I think this was the hearing when the judge wasn't...
Well, it's apparent he wasn't
very well
because he refers to it more than once.
But the simple fact is an application was made for funds which we say should have been uncontroversial. Pay my current solicitors, please, in a sum far less than my wife is paying her solicitors. And in the context of this case, a very modest fighting fund when all sorts of things are up in the air and in different countries. Where my wife's spending a vast amount, and that wasn't available either. And that caused real difficulties. And of course, it might be said that whatever was right at the time, the then current solicitors are now previous solicitors, so it's just a mere debt. It is a mere debt. It's another debt against the father in circumstances in which child 2-1 and the mother don't have to labour in relation to there being outstanding debt, but because this wasn't dealt with in a way which, frankly, Mr. Justice Cobb and Mr. Mostyn in Rubin say it should be, the father was left without outstanding debt.
Yes, I'm looking at the time.
Well, yes, I hope our position is set out in our skeleton. We
Yes.
will find the bill of costs.
We've got the bills. Well, there's certainly a bill at page 256, another one at 257 of the 256 post dates, because I think that's July. Right. The one at 257 is dated 31st of May, and that's 44,754 after deduction of pet monies on account. So it's
But we'll be able to look at this, I'm sure, with
Yes.
full documentation. But in fact, things have moved on a stage since the application for permission to appeal was made, in that the current solicitors are now the former solicitors.
Yes. But if, as a matter of law, the previous bill ought to have been paid by a funding order, had that happened, the father wouldn't now be the subject of that debt with previous solicitors, which those solicitors can choose to enforce as and when they want to by legal action if they choose to do so. Putting the father, A, in a different position to his daughter and his ex-wife, but secondly, putting the father in a disadvantageous position in relation to where he should have been if fairly well-known case law had been applied. And this isn't a case where his £47,000 came out of nowhere compared with nothing spent by the wife. It was a case in which there was significant spending by her on children matters.
so. Can you tell me what order do you invite us to make?
Well, we invite you to make an order discharging, or effectively providing for the payment of that, and providing for the payment of the £50,000 for which Mr.
Right.
Tyzack asked.
So it was 47 for historic, 50 for prospective.
But yes,
And who, with whom, because we've now moved on, I know this is asking for later fact, with whom have those 50,000 been incurred? With,
I have to check what the...
because you have received monies, haven't you, for the purposes of these appeals?
Yes. So, certainly the bulk of that will have been spent with Vitallingham K, current solicitors. Whether there was a residue between the date of the final bill that we've seen and the withdrawing of instructions,
Yes, okay.
I'm afraid I don't know.
Yes. Right. Right.
I'd say it's a peculiarity of this situation that although at the time that you issued your application, you were with one solicitor, now you're no longer with that solicitor. And so the outcome of the appeal does not affect access.
No. But it does affect whether the father is left with a debt which wouldn't otherwise be a debt,
Yes.
in the knowledge that solicitors are suing for their debts.
Yeah. Thank you. Right. Who's making submissions?
I'm making submissions.
You are. Thank you.
I produced what was the third skeleton last week in this matter, and apologies for the typographical error.
No. Yes.
In this. Can I just deal with the last point first, which is access to justice? Yes, indeed. The father's legal team, including his current solicitors, who were, I think, his fourth or fifth firm of solicitors that he instructed back in the day, have funds on account for this appeal. It was agreed on the 7th of July that £84,000, including VAT, was to be paid to Vitallingham K for the appeal costs. And that's 70,000 excluding VAT for my client, for her legal team. And that if there were any fees incurred above that on behalf of the mother, then it would be released to the father's team on a pound for
Do we
pound
have
basis.
schedules for this hearing?
I haven't seen one.
Could these be sent to us, please,
Certainly.
by all parties? And could you inform Mr. Hames too?
Yes.
His solicitors must send
So
to
that
my
was on the
clerk.
7th of July.
to my clerk by
So
the end of tomorrow.
that was on the 7th of July. That funding was agreed for this appeal
Yes.
to ensure that the father was, may say so, more than adequately represented for today. And that's why we say that really events have overtaken the arguments for that £50,000 money on account, please, for future children proceedings, when in fact 70 is agreed for this appeal. If we go to the transcript of the judgment concerning the £47,000, if the court looks at internal page 31, but it's also got a 34 in the right-hand corner. Obviously, his lordship was dealing with the historic fees of Mr. Carruthers leading up to that hearing of the 13th of May, and he says at the bottom, hang on, how can you make a claim in looking at the first bit in respect to the hearing on the 13th of May, when I rightly or wrongly decided against father and ordered him to pay her costs. He ordered costs, of course, which wasn't appealed, didn't form part of this main appeal, costs against the father. You cannot simply say, oh, well, forget all of that. Then there was a hearing on the 20th of May, which you've got cost order. I just simply do not see this. How can you possibly claim cost allowance with respect to the hearing, which your solicitors undertook, knowing that there was no cost provision in place for it, in respect of which, as I say, rightly or wrongly, they were not successful and were ordered to, your client was ordered to pay costs. See, they mounted an unsuccessful application, which of course has been unsuccessful on appeal for your lordships today. And it was a risk that Mr. Carruthers undertook. And I fell foul of trying to work that out during the actual hearing on the 13th of May, whether or not the £90,000 that had been paid to Hughes Fowler Carruthers was some of it was being used for the children proceedings, and I was corrected during that hearing that actually no, that's been ring fenced for the financial proceedings, and actually there was nothing in the pot for the children proceedings. The father receives £20,000 a month, 10,000 of it which is for rent, and the rest of it is for living expenses. So he's not destitute, and he was able to fund litigation on occasion when he hasn't been represented by one of the many reputable firms of solicitors and counsel that he's instructed in the past. And of course he's represented himself more than adequately as well in the past. So we say there's been no issue about an access to justice. In many respects he's had too much access to justice, and that's the issue that the learned judge was trying to deal with. He was trying to cut down this Japanese knotweed that kept growing up in these proceedings, and to ask for £50,000 on account for effectively what we've heard is correspondence, but for making further applications, in our submission, the learned judge was correct in his analysis in refusing the applications. But if one looks at the actual order, I couldn't see where the applications...
Well, is that what the judge did? As my
Yeah.
lord pointed out, he then says, I'm not dealing with it today.
Indeed.
So what
That's
was
why I
everybody's understanding at the conclusion of the hearing?
That's why I went to the order itself. I couldn't see a section in the order which refuses...
Well, it says what's permitted.
Yes.
So
Does it
by
say what's
implication, it
Yes.
refuses everything that other than those items which are permitted.
Well, counsel on the day, of course, he was making those applications when the learned judge said, I'm not dealing with them, said, where's the effective? And we've seen that in the transcript.
You weren't there, were you?
I was having a watching brief, so I was
were
sitting
you?
on the side.
Okay, so you were there.
I was there.
Well,
Mute. My old friend Alexis Campbell,
Okay.
his counsel, was there.
And the appeal's been argued, and you seem to have responded to it on the basis that the judge did deal with it, or intended to deal with it,
Yes.
and we're divining his reasons from the transcript.
Yes. That's the only place that one can divine it from.
And do you say that's, or that he didn't decide it, which you're saying he did decide it?
I can't see there's a specific section in the order that he's dealt
Paragraph
with.
38.
Sorry?
Paragraph 38.
Paragraph 38 of the
order.
Refer to my own frame.
Right. Okay. Thank you. So he did deal with it.
Thank you. That's what I was looking for.
Right.
But one can understand, with great respect, the learned judge. 13th of May, those are the historic costs. He refuses the application. He grants costs against the father for making that application. It's upheld on appeal, and it's a risk that the solicitor took, and it didn't affect the father's right to access his ability to instruct leading counsel for this hearing. And we respectfully submit that that means the decision was sound. It didn't affect anything on the ground, as it were. And that's why, again, going back to my gardening analogy, paragraph 8 of our respectful submissions on this point.
Yes.
I should also say that Miss Williams is behind me, who's junior counsel at that hearing on the 10th of June.
Yes.
For completeness sake.
Yes.
That's why we say he's trying to inject some kind of proportionality and reflection in the balanced thinking, in the father's thinking. Made cost orders in January, made cost orders in May. Father coming back saying, well, can I still have my fees paid that were disallowed before? No. Can I have a fighting fund? No, with great respect. And so we respectfully submit that the learned judge was correct to adopt that approach. Thank you very much.
Yes, Tyler.
Well, just as the proportionality that may or may not have been injected was injected on one side only. The mother's withdrawals from Coots and the mother's fees have been astronomical, and through this period were far, far higher than the father's. It's not the purpose of the LASPO or legal costs regime to achieve anything other than a level playing field. What, for example, Mr. Holman did last year was to make the standard pound-for-pound order, which is the mother shall be prohibited from spending a single penny on her solicitors, save to the extent that she provides similar funding on a pound-for-pound basis. That's the level playing field and injection proportionality approach to this, not allowing the order of Notting J to stand, which gives the mother wholly unlimited access to funds, whilst not allowing the father access to funds for the same sorts of reason, the same costs as the mother was incurring them.
Thank you. Something else?
Going back to the main appeal, the Lordship asked if there was anything else. I simply wanted to highlight paragraph 42 of our skeleton submissions. We talk about the passports, but of course there still is an order that my instructor says hold on to the passports. So when the Lordships deal with your judgment, could you
Well,
please keep that in mind?
I'm not sure that we need to deal with that in the judgment. That's a matter that can be raised when the order is being discussed.
Yes. Certainly.
Yes, well, thank you very much. Thank you all very much for your submissions on this application and prospective appeal, and thank you all very much also for the comprehensive submissions you provided in respect of the earlier appeals. So we're going to reserve our decision on this matter, permission to appeal, with appeal to follow if permission is granted, and everything I said in respect to the judgment obviously applies to this one, and we will endeavour to get our judgments to you as soon as possible. So thank you very much.